Good morning, everyone, and welcome to T's discussion today around the Employment Rights Bill. I can see that we've got a number of familiar and new faces joining us today, so we're really pleased to have you joining today's webinar. We'll be talking for about an hour around the Employment Rights Bill and how that may affect your business. And this is the first in a number of T's webinars and also workshops and seminars that will be around this topic, which will be ongoing really for the next couple of years. So please do keep an eye out for those. If you find today interesting, please let us know and let us know about topics that you would like to focus on more or otherwise, and we'll be delighted to help if we possibly can. And we are there to help. Now, in terms of housekeeping, a few points to mention for today's webinar. First, thank you everybody for coming along today. We know that everyone's busy, and of course we picked a low news, no news day of all days to commence with the American election, which I'm sure some of you have been following. But for today, there's a Q&A section for you to raise questions as we go along. We won't be answering questions as we go along. And those of you who have attended my seminars will know that we normally do answer them when we can in the moment. But the way that this is run, this is recorded. The recording will be available after today, and time permitting and subject to what questions we get, we'll be looking to answer questions at the end. And if you have questions that are particular to you that you would rather we deal with privately, by all means drop me or my co-speaker today, Nick, or any of the team an email after today, and we can pick that up as we need to. Now, I'll introduce you briefly to the team, including Nick, who is speaking today.
Yeah, good morning, everyone.
So Nick's going to take the second half of today, and he's a solicitor in the employment team. And you can see, again, for those of you who know T, a number of familiar faces there, including Catherine, Ola and Arabella. And thanks to Nick and Arabella, along with the wider team here, have put a lot of work into these slides today to try to cut through some of the jargon of this new employment bill and move on to what it could mean for your business, because I know that's what all of you are so interested in hearing about. Lots to cover today, and we're going to focus on some elements more than others, in particular unfair dismissal. But you'll see that just looking at this, there's a lot to take in here. There's a lot of change on the horizon. And today and our future webinars and advice are about helping ready your business so that you're best suited and best ready for this period of change. That having been said, you'll see that from the topics we're covering today, very little of that for those of you attending, many of whom I know are very experienced HR and business owners, will understand that these are not new topics, but rather it's refinements to those areas of law. When does it all come into force? Well, that's interesting. So the bill was introduced on the 10th of October as part of the government's manifesto pledges and commitments to really ensuring more equality in the broadest sense of that phrase in terms of labour relations. And you can see those these visuals are not done by me, but they're done by someone much more technically minded than me. But you can see that we're only at the first two early stages of that first stage of the bill going through the House of Commons, with much more to follow. And what that means is we're probably looking at most of these changes not coming into force until 25-26, and that gives us time to prepare with the help that we're giving today and beyond. Unfair dismissal. This is the headline grabbing point insofar as there is to be protection from unfair dismissal from day one. Now, if we just think about tribunal claims and the cost to businesses in time and money, whether defending proceedings or paying an award, I think it's helpful to share a few statistics on this and why this is important to be ready. The highest award to date in the tribunal, in the employment tribunal, was 4.5 million. And that goes back to 2011. So taking into account inflation and change over that period, you can imagine what that could be now. Interestingly, and I'm just reading a few figures here because they're helpful to illustrate the point, I think, The highest award that was reported for 22-23 was 184,200 for unfair dismissal, which is the topic I'll be talking about in a bit more detail in a moment. Rising, and again, this is relevant here when you have this disability or discrimination claims, to 1.7 million for a disability discrimination claim under the Equality Act, and 995,000 for a sex discrimination claim, again under the Equality Act. Claims in terms of numbers, we are in a place where as a team we know that we are busy, and we know that people bring, unfortunately, speculative claims that may have limited merit. But the total number of claims that actually got through to a tribunal last year was 85,352, which sounds a lot, but actually is a slight drop on prior years. So that's, again, an interesting context, I think, to mention. Now, what do we have here? So what we have here is protection from day one against unfair dismissal. And that removes the 2-year qualifying period for unfair dismissal protection. Now, those of you who have been around this game for some years will recall that we had the 2 years, that was then reduced to 1 year, and now has been increased back to 2 years, with it now reduced to a day one right, unless the dismissal is in the initial period of employment, which is going to be like a probationary period, which we think will be 9-month duration, but is yet to be confirmed. And the interesting point here is, well, what does that mean? Does that mean we can simply dismiss during that 9-month duration? It doesn't seem to. What the legislation and the accompanying government guidance talk about is allowing for the statutory probation period or initial period for there to be a lighter touch in the process. You'll be aware that there is a process for disciplinary and performance issues, in particular under the ACAS Code of Practice, and you will be aware that failure to follow that can be relevant to the fairness of the process and can also be relevant to the compensation that may be awarded. We don't yet know how this lighter touch approach during the probationary period will play out. One would hope that it's all drawn together smoothly, consistently with the ACAS code, and certainly the guidance I've seen and the details of the bill that I've seen all point to that being the intention. Watch this space, okay? But I would also say this, and we have a double-edged sword here, I think, which is that all of you are in business and all of you are seeking to do the best by your clients and by your staff. And many of you will be aware that where an individual hasn't worked out, we part company with them during that initial 2-year period. But regrettably, what that can prompt is speculative claims where you don't need 2 years service. So that can include claims for discrimination or whistleblowing and such like, which have no requirement even now for any length of service. Sometimes those claims are valid, and that's a different point. But we do come across claims that are put under that route to get around the current 2-year rule. So I think what this change may mean is that that may not be quite the issue it presently can be, okay? But because that right is now a day one right, you can't simply jump in and dismiss someone because it ain't working out, okay? And we would strongly recommend ensuring that you use this period as we head towards these changes to make sure that you have a good process on probationary periods, that you have a good process of managing, in particular, performance and conduct issues, and that you ensure that your managers are empowered to understand what processes they should follow and to ensure that the managers do follow those processes for consistency. And all of these things will be ever more relevant in the future, but really and truly are relevant now and help guard against those speculative claims now. And I will talk about the reasons for dismissal, which will still be relevant in a moment. But before I do, keep in mind that there are other changes there under this bill. So one of them is that it's likely to be unlawful to dismiss women returning from maternity leave within 6 months, except in what's described as very special or limited circumstances. We do not yet know what those special or limited circumstances precisely will be. We do not yet know what the process will be. And you'll see that there is today something of a running theme about us, in the way of Donald Rumsfeld, perhaps, knowing what we know and knowing what we don't know. But we can say that all of these things are in the bill, and all of these things are likely to be brought into force eventually over the next 2 years in one shape, form or another. The probationary period is subject to consultation, and as Nick will talk about later, we're going to talk about when we think these rules on unfair dismissal are likely to come into force, but we're probably talking autumn 2026. Now, I want to touch in a recap now just upon the reasons for dismissal that are potentially fair reasons. And you'll see we have conduct or misconduct. Okay, it's not about being good, it's about being bad. We have capability or qualification, performance issues. Okay, redundancy, contravention or restriction of a duty. So if it becomes unlawful for that person to be employed generally or potentially in the role that they're doing, and the catch-all under section 98(2) of some other substantial reason. It's unlikely, and it does not appear to be the case from the employment bill, that in general course of things those reasons will change, and we would still expect those to be the reasons that would be the primary reasons that you would be looking at dismissing people, numbers 1 to 4. Where we get to now with the changing rules is you have two considerations here. Do you have a potentially fair reason? And have you gone about the process reasonably and in accordance with law? That's the case now for anybody with more than 2 years, but we'd counsel and recommend that you be thinking about that as general practice and ensure that your managers understand the importance now of following the process and doing so consistently and following your internal procedures and ACAS code, so that you're as ready as you can be for when these changes come in, and it should be a smooth transition when the changes do ultimately arrive. Flexible working, and these are again, I feel a bit sorry for Nick because I've given him some of the bigger topics that are less interesting, and mine are more interesting, but we'll see where we go to with that. And the flexible working one, I think, is a really interesting one because it comes up very routinely for our clients. And we'll come on to in a moment the reasons that one can decline a flexible working request. The reality is that it's always been the case that anyone can make a request for a flexible working arrangement, which could be a change in their working hours, which could be a change in their place of work, which could be a change in their working days or other. We also know that in reality, post-COVID, some of the rationales for declining a request have become perhaps less arguable. We also know that there has always been the risk of ancillary or separate claims associated with declining a flexible working request. And what we mean by that is that if you decline a request that statistically impacts, for instance, more of the female proportion of the population than the male proportion, or of the workforce, and more pertinently, that could give grounds for a claim for indirect sex discrimination. There may be claims for disability discrimination and associated failure to make reasonable adjustments under the Equality Act. There may be claims for constructive dismissal. So we would always advise our clients to be careful not to dismiss a flexible working request out of hand. And to that extent, the new regulations, and for your reassurance, don't fundamentally change the picture. But there is a change, and it is one which must be kept in mind, in that the request must be considered, and if you decline the request, and we'll recap on the reasons in a moment, any refusal must be reasonable and must be explained in writing. And it's this reasonable element which is the particular new element to keep in mind, and question mark how one will judge that. Is that to be objective? Is it the employer's opinion? Is it what someone as a bystander would say? Do we take into due regard the employee's circumstances? Much remains to be seen on that. But again, I think this is one where we can be ready and actually can be heading off other potential claims by demonstrating that we've given due and careful consideration to the request. And we've explained our rationale and why it's reasonable to decline a request, or, of course, the compromise is to offer a compromise and find a way that does work for everybody. If we can now quickly recap on the reasons to refuse a request, and that is the burden of additional costs, detrimental effect on ability to meet customer demand, inability to reorganise work amongst existing staff, inability to recruit additional staff, detrimental impact on quality, detrimental impact on performance, insufficiency of work during the periods the employee proposes to work, and planned structural changes. Now, it's there, okay? And I know that many of you will have very good business and gut instincts about what is or isn't going to work for your business, particularly if you're an owner managed business and you know your workforce and you know your clientele and how things work. But we at Tees also know that the tribunals dislike and tend to punish decisions where we say, well, I knew that was going to be the case, or which appear to be based on received wisdom or shooting from the hip. It will become increasingly important that you can demonstrate an evidence-backed, fact-backed approach to your decision making, and then you'll be much more resilient to speculative or other claims. 0 hours, and again, this is a biggie, and while some of the others are ones where you could make a decision, I think, commercially, to perhaps wait and see how things play out over coming weeks and months and years, in some cases. It seems to me that the change around 0 hours contract and the intention expressed by the government to ban exploitative 0 hours contracts and most fire and rehire practices ought to be banned or restricted is one which, for some businesses, will be important to give due commercial consideration to now. If your business is geared towards a lot of 0 hours workers, you're going to have to be thinking sooner than later about whether that will work when in the future a change in shift at short notice will prompt a ground for compensation, that an individual who's been working for a prescribed period, which is to be confirmed in terms of the duration, will trigger a right to guaranteed hours, and with a process to follow as to whether that is coupled with a variation of contract or a new contract introduced, with reasonable notice of shifts. And with all that in mind, if your business is working in a way which is at odds with these changes, we really would recommend at Tees that you start thinking now commercially about what's going to work for your business in future, because as with all things, the bigger the ship, the longer it's going to take to turn. And this will be an area where you may need to be thinking economically, commercially, as well as legally about what the future may hold for you. And maybe that's a good opportunity for some of these businesses to be reflecting on what works well and what doesn't, and how we make sure that we have the best workers doing the best work. That's beyond the core of today's discussion, but certainly may for some businesses present some opportunities. Now, I should add that there are stings in the tail, and there are lots of little stings in the tail with this bill and the legislation that's going to follow. And that includes that it will be automatically unfair to dismiss an employee for refusing a change in contract unless financial difficulties and change is not reasonably avoidable. So again, this is limiting the flexibility that some employers may enjoy now, for good or ill. But our recommendation is to embrace this and gear up to this and get ready and make the most of the opportunities where there are them, and make sure that you're as ready as you can be to guard against those speculative and, as we've said, potentially costly in time and money claims. Now, collective redundancy is an interesting one that will affect some businesses more than others, will affect some businesses as a once in a business lifetime event, but with lots of those aforementioned stings in the tail already. Now, this is different legislation at its core to the Employment Rights Act, and the legislation relating to collective redundancies dates back to 1992. The legislation around collective redundancy is designed to protect where 20 or more employees are made redundant within a 90-day period. And when those collective rules apply, you will be mandated to follow a fixed period of redundancy with elected representatives. You'll be mandated to notify the government, DTI as was, BIS and so on, of the collective process, and failure to do so can not just give rise to due claims for unfair dismissal, but also protective, punitive, punishing awards of uncapped 90 days pay per employee, and also other potential civil and potential criminal liabilities. So it's not to be ignored. There's a care to have around this, and the big change is to remove the one establishment provision that was in that now fairly historic legislation, and every mention of the one establishment will be removed under the purposes of this bill. So what that means is that if, and I know some of the attendees have operations across different locations and others not, but for those of you who do, it's absolutely set in stone now, and we saw this on the horizon, and it's not such a gear shift, but it's worth keeping in mind that you have to look at the whole of your workforce as to whether redundancies are envisaged, and keep in mind that the definition of redundancy can in some circumstances be wider under that legislation than under the Employment Rights Act, section 139. There is also, and again, without giving too many spoilers away, something that Nick will mention as well, consultation on potentially lifting the cap of the protective award if the collective redundancy process is not followed, which one could, from a policy perspective, consider is relevant to the question of, ensuring that employers really appreciate the importance of employment rights and will feel the sanctions if they do not. And again, part of today is to give you awareness, but part of today is to ensure that we know that businesses have challenges too. This is not, the legislation seems oriented towards employees, but if businesses can prepare for these changes, then this will make it much easier for you as businesses in those circumstances to focus on things you want to focus on in growing your businesses, and when there is change management, making sure you minimise, reduce, eradicate the risk or cost of claims. And I think this collective redundancy point is a case in point. Now, there is one further point which I'll mention, which for today's group is of less relevance, but can come into relevance for some of you or some businesses, which is that the maritime redundancy notification loophole, if we can call it that, which you may have seen with regard to an extent the P&O issue, is to be closed by the bill, and there's a specific section under collective redundancy change in relation to ships' crews. Now, we won't deal with that today, but in the event that that is relevant to your business, and we do know of some of our clients who it would be of some relevance to, let us know, and we'll be pleased to talk to you direct on that as a separate and niche issue. Now, family leave. Again, this is one that was mentioned during the Labour manifesto and approach on the election, and brings in various changes that I think by and large are to be welcomed, but do bring new challenges and considerations for employers. So we have day one rights to bereavement leave, paternity leave, shared parental leave. And bereavement leave exists presently, but that's to be expanded to all sad and tragic losses of a loved one. That is, we understand, to be unpaid unless an employer chooses to make it paid, but it does introduce a legal right. By and large, again, most of our employer clients would, of course, look at such tragic and sad circumstances supportively, but keep in mind that legal right. The other thing that I would mention, as well as the day run right, is the repeal of the restriction on taking paternity leave after a period of shared parental leave. And of course, that again may introduce a new logistical headache for some employers, and it will be something that you'll want to be aware of in good readiness for when these rules come into place, so that you can plan and ensure that you're ready. And interestingly, as a side point on that, when we were talking earlier about flexible workers and 0 hours, there will be some excluded workers from that, and there will be some exclusions from those rules. And the reason I revisit that now is because if you engage someone on a fixed basis for a specific task, for instance, cover for a colleague, that may, to be confirmed, be one of those circumstances where the new rules around guaranteed hours and to be offered guaranteed hours are not quite enforced in the same way. We will keep you advised as to those changes and keep a lookout for our updates, because we'll be sharing those both in webinars but also in due course on social media. But I would recommend that you keep an eye out for those, because they could be really relevant and valuable, and to be aware of the potential discrimination claims that can arise. As I said to you earlier, the claims that were most valuable last year were the claims under the Equality Act rather than the employment right, where there is uncapped compensation available and availability of a claim for injury to feelings, which can really increase your risk and liability. Again, part of Labour's manifesto and pledges, minimum wage, and you'll see that there's going to be a gradual increase in the minimum wage tied to inflation or cost of living. From April 25, 21 and over will rise to £12.21 an hour. 18 to 20-year-olds will rise to £10 an hour, and then the rise for apprentices to £7.55 an hour. And with strengthened measures to ensure equal pay for equal work and to address pay disparities. And again, Nick will talk through with you some of the changes that are happening around enforcement and what we see as a policy decision to really ensure that employers are aware and that there are repercussions for employers who don't comply with the rules. Now, again, we would hope that this should not of itself come as too much of a surprise, and it's something to prepare for when these changes come into place, but it's one for planning and thought, particularly when coupled with the recent announcements around the budget and national insurance. Statutory sick pay, removal of the lower earnings limit and the waiting days, the 4 waiting days at present. Many employers will, of course, pay more than statutory sick pay initially anyway, but the cost of illness, there's a BBC quote that we've included there, and I'll just read from that if I may. In the UK post-COVID, health-related benefits costs have surged from 36 billion to 48 billion in the last financial year. And in particular, this was under the headline "Sick Pay Time Bomb that risks a lost generation of workers." Mental health worsening during successive lockdowns. Now, what do we do about this? Well, the slide is ostensibly there to help you, to inform you as to the changes. But it seems to us that this is another area where businesses may look to the positives in reflecting on what can we do to ensure that our workforce, insofar as possible, has every opportunity to contribute, and that we seek to address health issues, whether from access to employee assistance programs, mental health first aiders, through to key point for all of today's slides and all of the advice we give, good communication with staff to ensure what is the issue and what could we do to help you back to the workplace to help productivity, to help the worker, and to allow the worker to take pride in coming to work, and to be able to do so. And all of these things will become increasingly relevant as the cost of sickness absence inevitably continues to rise. Now, I hope that's been helpful for this first half of the webinar. I am now, I think, going to hand over to Nick to take things from here with some really interesting other content that comes out of the employment bill. And thank you for listening so patiently so far. Over to you, Nick.
Yeah, thank you, Rob, and good morning, everyone. So yeah, as Rob said, I'm now going to talk and run through the second half of the slides on the presentation. I'll then be handing back over to Rob, who's going to be discussing how we can best prepare and plan for some of the changes ahead. So to begin with then, looking at equality and anti-discrimination. Now, you would have seen that the existing equality and anti-discrimination laws are set to be strengthened with new measures included to improve, namely workplace diversity. In order to encourage employers to be more proactive in their efforts to reduce workplace sexual harassment, last year Parliament passed the Worker Protection Act, as many of you would have seen. Now, that particular piece of legislation introduced a new positive obligation on employers to take what was described as reasonable steps to prevent sexual harassment of their employees in the course of their employment. And that was obviously defined in the Equality Act. And as I say, the bill somewhat now builds upon that. So what is it that's actually changing? There's going to be a new obligation on employers to take all reasonable steps now to prevent sexual harassment. Now, that might sound like quite a small change, but from our perspective, it's very significant. And regulation will follow that sort of further specifies in detail the steps that are going to be that needs to be regarded as reasonable. So there will be some further guidance on that. There's also going to be the introduction of a broad duty for employers to take all reasonable steps to prevent harassment of employees by third parties. So, for example, by clients, by suppliers, or members of the public. Now, from our perspective, this, of course, does sound like a very broad duty, but it can be addressed by measures that you can reasonably put in place, which we'll come on to in just a moment. In addition to that, we've also seen from the government's proposals a strong commitment to end pay discrimination by expanding the Equality, Race and Disparity Bill to make it a mandatory change for large employers to report their ethnicity and disability pay gap. And there's also going to be a move towards a single status of worker and transition towards a simpler two-part framework for employment status, i.e. you're either employed or self-employed. So, I mean, for business owners, the benefits of these changes will include, more inclusive workplaces, improved employee morale, and compliance with legal standards fundamentally. However, implementing these changes can be quite a tall order. So, we would obviously encourage you here at Tees to, review your policies, make sure that you are training staff where possible, and having monitoring measures in place to ensure that you are compliant. And this can be challenging, but it's something that you're going to have to, keep a close eye on. Investing in diversity and inclusion and regular training, etc. That will help ensure your compliance and really just foster a positive work environment. As you'll appreciate, employees nowadays want to work for organisations that are a lot more transparent in this area. So when we're talking about, as I just touched upon, trying to prevent sexual harassment by employees by to prevent harassment of employees by third parties, as I said, that seems like quite a broad thing to achieve. I mean, an example of that, for example, could be, a delivery driver who turns up on site on your site and makes an unguarded comment to a member of staff on reception, for example. How do we go about addressing that? How do we ensure that doesn't happen? And how can we avoid, coming under scrutiny by our staff for failing to prevent those incidents from happening? And I've just got a few points here that I'll just read through in turn. It was points that we had considered would be sort of best for next steps in this. So one here is develop a robust anti-harassment policy. Again, Tees would always be on help to assist in that regard. conduct regular risk assessments, training and awareness, clear reporting channels, prompt investigation and action when incidents have occurred, creating a respectful workplace culture, and ultimately monitoring and reviewing policies and procedures. So looking at gender equality reporting, now the current gender pay gap reporting requirements are set to become a lot more detailed with mandatory action plans to address gender disparities. For those of you that are interested, this area is sort of governed by the Equality Act, Gender Pay Gap Information Regs in 2017. But the bill is going to be introducing a new provision which will require organisations that have more than 250 employees to publish what's been described as an equality action plan every 12 months. The plan should include steps that the employers take to advance equality and opportunity between male and female employees, including how the employer is addressing the gender pay gap and how the employer is supporting employees going through menopause. Apologies, sorry, can we just go back one slide there? Employers should really start considering the steps that they're going to be taking in this area before the disclosure of these obligations and before they come into force. Really, the purpose of this action plan is for companies to provide greater transparency in this area and progress towards gender equality. As you'll appreciate, as I said, people nowadays, they're increasingly looking to work for companies that are more inclusive, have a diverse workforce. From a business perspective, you need to be trying to take active steps to improve equal opportunities, as that will certainly enhance, business reputation, company reputation, broadly speaking. Again, some of the challenges that you could face in this area, of course, are collecting accurate data, developing effective action plans, and ensuring ongoing compliance. So much as we previously just touched upon, we would always recommend them regularly reviewing any policies that you've got in place, implementing action plans to help actually address those disparities and promote a fairer workplace. Right, public sector. So the bill has also included some specific provisions to enhance employment rights for public sector workers, specifically relating to the outsourcing of public sector services, just generally. There's going to be regulations that will essentially prescribe outsourcing contract provisions to prevent less favourable treatment of outsourced workers. The bill provides for the establishment of an adult social care negotiating body with the aim of establishing a fair pay agreement in the adult social care sector. The government has also said that following implementation and review of these arrangements, it will assess how and to what extent such agreements could benefit other sectors. And finally, on this, the bill contains provisions reinstating the school support staff negotiating body to establish national terms and conditions, career progression routes, and fairer pay rates. And sorry, again, for those of you that might be interested in the legislation on that particular area, you can look at the duties of equality under the Equality Act and the Civil Service Management Code, which will provide some further details on that. Now, as Rob mentioned, briefly touched upon the changes that are going to be happening with enforcement. And I'll cover this off briefly because there's not a great deal of information on this at present. As you'll appreciate, the employment rights are primarily enforced through tribunals at the moment. The Employment Rights Bill proposes the establishment of a new Fair Work agency to oversee the enforcement of employment rights. We really see this as an amalgamation of other agencies, and it remains to be seen how this will actually play out. There has been a policy drive on more ability to enforce rather than less. And as Rob mentioned, the bill also includes potentially lifting the cap on the protected award for 90 days pay if the collective consultation rules are not followed in the case of collective redundancies. And now, as I said, the agency will bring together existing enforcement bodies which will be responsible for ensuring compliance with employment laws, including holiday pay, minimum wage, and enforcement of the working time regs. It will also provide some guidance and support to employers on compliance just generally. I mean, in terms of the benefits for your businesses, this new agency will include a streamlined enforcement process, which ideally will offer better protection for workers and clear guidance for employers. There will be some challenges around this, of course, and as I said, it remains to be seen how this will play out, but it's worth keeping an eye on this new agency as and when it comes into play. Just touched upon that, if we mind going to the next slide. Trade unions. So the bill has also contains a significant set of changes to trade union legislation, which are collectively expected to create what's been described as, or what's been dubbed as, a golden age for trade unions. The Department for Business and Trades recently launched a consultation, which has been called Making Work Pay. It's a consultation on creating a modern framework for industrial relations. The consultation itself will be seeking views on the following points, which I'll just read out to you, just worth taking a note of. Simplifying the amount of information unions are required to provide an industrial action notices, strengthening provisions to prevent unfair practices during the trade union recognition process, removing the 10-year ballot requirement on political funds, securing a mandate for negotiation and dispute resolution, extending the expiry of the strike mandate, reducing the industrial action notice period, updating the law on repudiation of industrial action, updating the law on prior call, and the enforcement mechanism for rights of access. You know, this consultation, it confirms really the government's intention. Once the bill has received royal assent, it's really, like I say, it's confirming their intention to modernise trade union law. The consultation will be closing on the 2nd of December. So for those of you that will be finding that information of relevance, as I say, please take note of that date. It's the 2nd of December. And finally, we've got some additional measures here. I think there is one further slide I'll be talking to just on collective grievances. But there are some measures that are going to be advanced and modernised alongside the Employment Rights Bill. The government's also confirmed a number of steps in relation to employment rights, which will include a full review of the parental leave system, and considering paid carers leave, as well as consultation on single worker status, as I touched upon briefly earlier, and the operation of the TUPE regs and allowing employees to raise collective grievances, as I said, which we'll touch upon now in just a moment. So yeah, as I say, collective grievances, as most of you will already be aware, collective grievance is raised when a group of employees share the same issue or complaint. The bill will be introducing provisions for collective grievances to be formally recognised and addressed. As I said, as yet, that also, you know, remains to be seen how that will play out. But it's a significant change as it ensures that collective issues are addressed fairly and consistently, you know, promoting a more collaborative approach in resolving workplace disputes. Under the Trade Union and Labour Relations Act, the ACAS Code of Practice on Disciplinary and Grievance Procedures, the process involves employees submitting the grievance in writing and having that signed by all parties involved. Employers are then required to investigate the grievance and hold meetings to discuss the issue. And following this, employers must provide a written response if necessary and follow up with further meetings. Now, I suppose the aim really of the bill is just to try and streamline that process as best as possible, really to just try and ensure that any concerns are addressed fairly and consistently, as I said, and promoting a more collaborative approach with resolving these disputes. As I said, the logistics of this, we don't know how are really going to play out. But really, it's just the idea being that ensuring that all voices are heard, really, with any issues. And obviously, fundamentally, they need to be maintaining confidentiality amongst all of those individuals that have issues or grievances to raise. Now I'm going to hand back over to Rob briefly, who's just going to be discussing how, as I said, we prepare for some of these future changes.
Thanks, Nick. And I hope everyone has found all of that information helpful. I certainly did, even knowing some of it. It was really helpful to hear from Nick with some of the consolidation of those points. And I think when we look at preparing for change, we know that the government paper Next Steps to Make Work Pay will confirm further detail on all of this, on the policies and how things will be played out. And as Nick mentioned, with the exception of the provisions in relation to union recognition, which is a slightly different process, consultation begins 25, and once regulations come into place, we're looking at the majority of reforms not taking effect earlier than 2026, and unfair dismissal reforms no sooner than autumn 2026. So what do we think about here? Well, I think Nick reminded me of a number of points there which we ought to be thinking about. But listening tonight, you may have thought and could be forgiven for thinking, actually, does the employer have a voice on this? You know, and if you look at the BBC report that says Labour's plans to upgrade workers' rights will cost businesses up to £5 billion a year to implement, according to the government's own analysis, which of course is a significant impact on businesses, along with everything else that you're trying to do to run your business. And I think where we get to is saying that in preparing for change, it's about awareness, but it's also about readiness. And readiness is ensuring that you have your policies and procedures in place. And when you're looking at your policies and procedures, thinking about, do what we have in writing, do those policies and procedures reflect what we do in practice? And if they don't, is now the time to reflect on that and understand why. Do we need to ensure, as Nick mentioned, around the points about sexual harassment, for instance, that we're getting better awareness and training for managers, and that we ensure that the whole workforce from top to bottom understands what's expected and what should be done? Is it that the policies don't fit how we act as a business, and that this is an opportunity to make sure the two marry up? And is this an opportunity for really grasping the nettle of collaboration and communication with our staff? Because we know, Nick and I and the team, that time and again, it's often the employee who has, for one reason or another, become disenfranchised with the workplace, who is the one that ponders the claim. And if we can make sure that we have good communication with staff, which of course is always the goal and is easier said than done, and couple that with the policies and procedure, and couple that with ensuring that we have the commitment to following the right best practices, then we're going to be best placed to fend off or indeed avoid claims being brought against your business. And when claims do arise, and they will, ensuring that you have a documentary trail that you can say, this is our policy, this is how we followed it consistently, and we did the right thing, so that when those speculative claims arise, and that will happen to most businesses at some stage during its lifespan, that you have the best chance to defend those with our help, and being able to empower you to take a robust stance and a commercial stance as you so wish. And I think, Nick, I don't know whether you had any other thoughts that specifically relate to your slides on that, but those are the key themes of approach on this as we ready ourselves for these changes.
Yeah, to be honest, I mean, I didn't really have anything more to add to that, really, other than just to say, you must be ensuring really fundamentally that you're reviewing, as I say, workplace procedures and policies, keeping an eye on particular deadlines for legislation changes and updates, and really just conducting assessments where necessary, if it be a risk assessment, or if you need to, for example, address any investigatory type avenues. I mean, I think really it's just keeping an eye and staying abridged of all the updates are on horizon. Yeah, Rob and I obviously, routinely deal with updating policies, procedures, etc. when new legislation comes into play. So it moves fast, so you do have to keep an eye on things.
I think that's right, and it's never changing area of employment law as it always has been. Now, just to, we don't, as it happens, have questions in the Q&A section, which you'll see on your sort of Teams front page, sort of midway through the top line, I think, if you have questions. But I'll just talk about another thought before we get to any questions. And if we don't have any today, that's absolutely fine. We know that we act for a very wide variety of clients working in lots of different sectors. But we know that a common thread for many of our clients is that it's your business and it means something to you as a business. And we get that. And we get that in supporting you with making the right decisions for your business. And what we've talked about today has included some general content, but what works for one business will be slightly different for another. And what we're about and what we hope you've taken from today is that you're empowered with some knowledge to make it work for your particular business that we can help you with. Now, my final point to mention on a recap about the unfair dismissal point is to really recommend that before you even employ someone, you get your ducks in a row. More than ever, it's going to be really important to ensure that you have got a good recruitment process and you've got a good retention process so that you can ensure that you bring on the right talent that has the same ethos and approach to work as your business, that has the right skill set. And dare I say it, this may be a time to be selective in your choices around that, in terms of making sure you have the right talent who has that skill set and not compromising, because otherwise it may prove more difficult to recruit, to part company with those individuals in future. But if it isn't working out, address it consistently and promptly, because if we allow problems to languish for whatever reason, and there's lots of good reasons why we can't always act on things promptly, but more than ever, that will produce stings in the tail and potential legal ramifications for your business that you would, I'm sure, prefer to avoid. We hope that that has given everybody a good roundup of where we are with the Employment Rights Bill. This is the first in a series of webinars. And of course, you heard from us today for the employment team, but the wider business law team and wider firms services obviously are available. And we'll be pleased to introduce you to colleagues across that skill set and experience set as need be. We've been going since 1913. We've got over 400 staff across 6 offices. And as I say, we've been very pleased today to hear that you've interest in listening to us. We hope it's been helpful. Please, if not questions today, drop me an email, drop Nick an email, drop the team an email, and we will be delighted to deal with those and help you with driving your business forward and making sure you avoid the pitfalls wherever possible. So unless we have any other questions or any questions, as I say, Nick and I will be available. Drop us an email, give us a call, call Ola, Catherine, or any of the team, and we'll be pleased to help in any way that we can.
Yeah, thank you, everyone. As I say, can't see anything in the Q&A. And just to echo what Rob said, if anyone's got any questions, by all means, feel free to drop any of us an email or pick up the phone if need be to discuss any queries. You're obviously more than welcome. And I think that concludes the webinar for today. So yeah, thank you all for your attendance.